We named our conference the Permanency Dialogue, and also, this meeting too. It's really a working meeting. There are things that are in process. There are things that we're thinking about, and we need to talk about. And again, have those hard conversations, and really think about what are the emerging trends and what are the issues that you as leaders need to be thinking about as we're going forward, because child welfare is never static, and neither is the field of adoptions. So I think this is an important area, and I've come to this job. I've been there a little over a year now, and there's some things that interest me. One of them is MEPA and getting the conversation and those hard conversations moving forward, and this is another area. And the Hague, we had the opportunity to go and meet with the State Department about the Hague and find out about it, and we wanted you to have that information. But I have really tried to initiate, and Jane and I are really want to work much more closely with the State Department, and really we think that there's some things to think about in the field because of the Hague. And we think that this is going to result in some changes. We think that some families who would have previously adopted internationally maybe are going to come to the States now. And so we want you to be thinking about that, and we want you to be thinking about how are we going to work with this population that maybe is going to be a little bit different than some of the families that have traditionally come to us. Second thing is that the Hague is going to result in some additional requirements for the states, but it's not the Children's Bureau area of expertise. But we want to be in the know about it. So the first few meetings we had was just so we could educate ourselves. And also, can we get our NRC staff trained and knowledgeable on it, and maybe use our NASAP as a mechanism to get the information out to the states. So that was the second thing. The third thing that we think is important for you all to think about, and for us to all continue to work on, and maybe have some discussions about next year at this time, is what about families in other countries that are looking on the Adopt Us Kids website and see some kids that they have an interest in? If there are kids in your states that are difficult to place, and first we need to work together, and I just have to say this again, my third area that I really am interested in is interstate and interjurisdictional issues, and we should be able to place kids. If we're going to have a national advertising campaign, we need to be able to figure out how to work together and place our kids across state lines. We have to figure that out together. But if there's a family in Canada or a family in Europe that sees kids in your state on the Adopt Us Kids website and calls up and says, I'm interested in those kids and they would be a great resource for your kids, we want to be able to have the information available to help you figure out how to do that. So this is the beginning of that conversation. And I just really feel like our best weapon is information, and our best resources in many ways are each other. And an attitude that we can work together and work these things out, and it's going to benefit our kids and families. So, I'm very happy for the opportunity to have this presentation. And our presenters today, the first is Anna Mary Coburn, and Anna Mary Coburn is an attorney advisor for the U.S. Department of State. And she provides advice and counsel on a wide range of international law issues with a focus on consular affairs. Her practice areas encompass international family law matters and children's issues, including intercountry adoption, child abduction, and child protection and child support enforcement issues. She was the lead attorney for the U.S. implementation of the Hague Convention on Intercountry Adoption and drafted 5 proposed and final regulations, including the DOS rules and guidelines on outgoing U.S. adoption cases. She also frequently works with foreign countries on child welfare and protection reforms. Before joining DOS, she was a legal consultant to USAID. She has traveled to provide technical assistance and training to other countries such as Romania, Cambodia, and Guatemala. Our second presenter today is Mickey Stebbing, and Mickey is the accrediting Entity Liaison for the Department of State and works with the designated accrediting entities to implement the Hague Adoption Convention and Intercountry Adoption Act of 2000. She is an attorney and a licensed clinical social worker, and she has worked for over 30 years in both the international adoption and domestic child welfare fields. In the Office of Children's Issues, she provides the link between the department and the accrediting entities as they begin to accredit agencies and approved persons to ensure that the procedures developed are in compliance with the standards and the IAA and that they are uniformly applied. She is working to ensure that the department will also have the necessary procedures and processes in place and available as implementation proceeds. So please join me in welcoming our two speakers. Thank you.
Good afternoon, and I want to thank Heidi for inviting us. It's fairly exciting to be able to speak to this group. I was struck by the luncheon presentation. I'm a friend of Debbie Riley's and also on the board of directors of CASE, so I have to mention my own personal involvement in the need for adoption-competent mental health professionals. So if you will indulge me for a minute, I'm going to lead off with that personal aspect of adoption. I'm an adopted parent along with my husband of 3 children from overseas, 2 of whom were in institutions until they were 12 and 9, and so they arrived in the United States with many post-adoption mental health needs, to the point where I would have to say most of the time my hair was like this, and my house was, let's just say, evolving on the dysfunctional level. And the search for adoption competent mental health professionals was difficult, was stressful, and it was particularly with a total of 3 children who all needed mental health professionals. And parents, that we needed help too from terms of family counseling as well. And so it was a long and difficult journey, and I would have to say, we found some good professionals, but they're not easy to find. They're really not. And we, we're not Medicaid health insurance. We have better options than many of the children that you deal with, but it was nevertheless very challenging. And I would like to just say that it still continues to be a challenge, because one of my children, who was 12 when he came, and had one of those classic dreadful pasts that most of the children you deal with have, was in therapy for most of his the duration while he's lived at home, but he's made it into college. But of course, that's a big transition for these kids. And the first thing we're looking for at the University of Mary Washington is some adoption competent mental health professionals right on the staff of their counseling services, because when I said to him, we need to find somebody down there, because the exit from the therapist here was tough enough. And he's like, Mom, I don't want to start with somebody new and doesn't know anything about adoption. And what I'm going to find down there is going to be a lot of people that don't know about anything about adoption, and we will be starting from scratch. So I encourage you in your post-adoption world to participate in the project that was announced and discussed today, because from a personal point of view, I can't tell you how important it is. I also, in my professional life, see a lot of disruptions and disillusionments mainly in the international world, and a lot may be too harsh because it's anecdotal, but I see more and more, because of the nature of the children's lives before they get adopted, is very similar now to the foster care system. I mean, they're coming from many caregivers, institutional settings, a lot of birth family dysfunction, and very limited social work or mental health care services before they hit the shores of the United States. And a lot of parents don't know how to deal with that, and they're looking for adoption competent mental health professionals, and they're desperate, because unless they get them, those adoptions are going to disrupt or dissolve as well. So I encourage you on the project, because it's really needed, not just for for kids in foster care. It's also needed for those children that for better or worse, it's about 20, for 20,000 children entering the United States each year, and they're not, contrary to mythology, they're not all under 2. Okay, so with that, I would like to talk about the Hague Adoption Convention, a subject that is near and dear to my heart. And what I'm going to do is Mickey and I are going to share this panel, and we're going to talk about the whole picture, but mainly focus on accreditation and outgoing cases. I'm assuming some background knowledge is necessary, so I'm going to give you the background. I'm going to briefly touch on the accreditation, but I'm going to defer to my colleague to cover that main topic. And then I'm going to talk about outgoing cases and incoming cases, because this convention covers both. So if you have children, like Heidi was talking about, who happen to get placed with Canadian parents, Mexican parents, relatives in the UK, this convention is going to apply if the other country is a convention country. So you're going to have another overlay of requirements to meet to do those placements. What is the Hague Convention? Well, there's an intergovernmental organization known as the Hague Conference on Private International Law. It's a website which is a key resource. If you have one of these cases or you have questions, this would be a good place to go. And in this, the Hague Conference, which does these multilateral treaties, there's status tables for each convention. And so the status table will tell you which countries are parties to the convention along with the United States. Right? And there's a couple of other treaties that are there, but the main one we're going to talk about today is the adoption one. What is it? What do they do? They make multilateral treaties. Multilateral treaties are when a whole bunch of countries get together and negotiate the treaty, and then you sign onto it without changing it. So it's not a two-way street. It can be, as many as 100 countries that become party to a multilateral treaty. They take a long time to negotiate, but they have the advantage of being internationally accepted. Right? It's just not two countries. It's more than it's multilateral in nature. We are parties to other treaties. Because you're in child welfare, you may come across these occasionally. The U.S. is a party to the Child Abduction Convention. We're definitely a party to the Adoption Convention. There's a new one that's coming online on child support enforcement, about moving child support across the international lines, whether the child's in the U.S. or whether the child's overseas. This will be very important for a lot of kids in developing countries to be able to get their child support. And the U.S. has already signed with intent to ratify that treaty, which just came online at the end of 2007. And we're optimistic that we will eventually become parties to that. In addition, there's another treaty on child protection, the 96 treaty, which we are also advocating for its ratification. And that deals with all kinds of long-term foster care arrangements, custodial care, child protection across international lines, short of adoption. All right? Custody disputes that don't involve a wrongful removal. And here are the 4 conventions, the 4 children's conventions, just so you have their titles and the shorthand. And they all are on the website of the Hague Permanent Bureau with their status tables. So here's my outline for today. I'm going to talk about the legal aspects of accreditation under this new treaty. I'm going to talk about outgoing cases and incoming cases. The Hague Adoption Treaty entered into force for the United States on April 1st, 2008. This means that there are now 2 kinds of adoption cases. There's Hague cases and non-Hague cases. This Department of State, was named the central authority. This central authority is the public entity in the country that has responsibility for enforcing the treaty, for answering questions about the treaty, about dealing with other governments, the diplomatic efforts. And so the State Department is the central authority for both the abduction and now the adoption treaty. HHS is going to be the central authority for the child support enforcement treaty. All right, so you can designate who you want as a central authority, and you usually look for the agency that has expertise. Right? If you wanted to know the specific countries that are Hague adoption countries with the U.S., we also post that list of convention countries on our website, which is a wealth of useful information, and that's www.travel.state.gov. And I culled here some sample countries that have signed on to the adoption treaty. Canada and Mexico, that's important for the state adoption managers because that's where most of the outgoing cases are likely to be going. The border states, at least when I've spoken to state child welfare professionals before, the anecdotal information to me has been, I've got a couple of these cases and the kids are going to Mexico, or if they're up in Minnesota, they're going to Canada. Other places, but that seems to be the phone calls that I'm getting. The China, in terms of incoming countries that are party to this, is China. We get about 3,000 to 4,000 Chinese children adopted each year. Guatemala, which is closed right now, but we had a large number of Guatemalan children. So these are major countries that we deal with have signed on to this treaty. Russia has not yet become a party, but it intends to, and Vietnam and South Korea are not Hague adoption countries. What does it do? Well, first of all, for every treaty, there usually has to be implementing legislation, and that was called the Inter-Country Adoption Act. The big thing that it does is it requires the accreditation of all private adoption service providers who provide services in outgoing or incoming cases. So instead of just having to be state licensed, if you're doing adoption services in a convention case, you have to be accredited by the state departments. Right? So we have a huge role on that, and we also have accrediting entities, and Mickey's going to talk more about that. But you may come across this issue, especially if you get questions from your parents or from your service providers where to refer them, and this would be, you can refer them to us in terms of the accreditation requirements. Also, you have lots of new case processing procedures for incoming cases, because that's the main thing people think of when they think of inter-country adoption, and there's lots of immigration law as well as case processing requirements that now affect the children who come from a convention country like China. Most importantly, we have a brand new federal overlay for a series of protections for children who may leave the country, leave the U.S. for the purpose of adoption. And that's what we call the outgoing case. That's our shorthand. If you're in a non-convention situation, just to clarify, if you're in a non-convention situation, then you don't have to be accredited. The state licensing, though, of course, still governs your adoption service providers. The old non-Hague or orphan procedures govern the incoming cases. And the outgoing case, that's if the child is going, let's say, to Russia, which is a non-Hague Convention country, then they would not apply. Right? So your first task is usually, okay, what's the country? Because then that's your big fork in the road. You're going to have to decide, is it a convention country or not? If you have trouble with that, at the end of this, I will give all my contact information, and we can help you discern the tables. Okay. Now we're in the point in the outline where I'm just doing the highlights, the legal highlights on accreditation. The big one, and I just mention this because this has really severe consequences for the adoption service providers who don't get accredited. But the bottom line is, as of April 1st, if they're providing services in a convention case, they have to be accredited, they have to be supervised by an accredited provider, and there's a couple exemptions. And if they're not, they're subject to criminal penalties. So it's a pretty strict regime. And I've found a few state licensing people calling me saying, we've got this adoption service provider, and they're doing Hague cases, and they didn't get accredited. They're not on your list. Right, so I just want to mention that in terms of getting the word out, because sometimes you do get accredited voluntarily, or you may be in a state which requires some form of accreditation of your public agencies. I want to make sure you understand that you are not the public authorities are not required to be accredited. Right, so you're empowered to do the outgoing cases, but there's no accreditation requirement. All right. What's a public domestic authority? That would be any authority operated by a state, a local, or a tribal government. How is the accreditation going to work? Well, it's working with two accrediting entities, some of which you may have dealt with. The Council on Accreditation was one of our designated accrediting entities, as well as the Colorado Department of Human Services. we did a whole request for proposals and evaluations of potential states as well as private accreditation entities, and these are the two that eventually stuck with us and also were qualified enough to do the accreditation. We had 300 applicants for adoption service providers, and to date we've done 226 have full or temporary accreditation, and 18 have been denied. What's an adoption service? I just put this in more for a top takeaway, because sometimes, you know, it's not just child placement, it can be more. This is a broader definition. So if the adoption service provider is engaging in any one of these services, identifying the child, securing consent, performing a home study, then they're likely to have to be accredited. If they're making any best interest determinations, if they're monitoring after the child's been placed, or they're assuming custody of the child, they're also going to have to be accredited. There's two types of adoption service providers. There can be accredited agencies, which are nonprofits. There can also be approved persons, which are individuals or for-profits, including attorneys. So it's a functional definition. So the lawyers of the world who are providing adoption services, not just legal services, also have to be accredited or approved. Does it preempt state law or stop your state law licensing requirements? No, they have to keep their state license. Does it change the licensing requirements for adoption service providers? You know, if they get federally accredited, do they still have to meet your state requirements? The answer is they still have to meet all your state licensing and regulatory requirements. What happens to them if they don't meet, if they are accredited by us and they fail to meet the standards on an ongoing basis? This Department of State is now, along with our accrediting entities, into an enforcement mode, similar to what states have always had to do. We'll be looking to you to help us make these tough decisions, right? But we can suspend or cancel the accreditation or approval. We can refuse to renew. We can require corrective action. We can impose other sanctions. The Department of State can also, we have a slightly higher standard than the accrediting entities, but if the accrediting entity refuses to take the adverse action, we can take it. So we have direct enforcement authority. And we can also debar, permanently debar, and temporarily debar. And the entities accredited, if we take these adverse actions, with the exception of denial, they have an opportunity to go to federal court for judicial review. So it's similar to some of your state licensing licensing regulations on adoption service providers. All right, now in the outline, I'm switching to outgoing cases, and we will have more information, like I said, from Mickey on accreditation. And I also wanted, especially on the outgoing cases, to encourage you, if a question pops into your mind, just ask it, because I know, you know, sometimes it's hard to wait till the end. And I'd be glad to field it as it comes up. First of all, I want to give you some information on the resources for outgoing cases. You know, because the great challenge of these cases is that you probably aren't going to get a lot of them. But when you get one, it's going to be labor intensive. And I've already had a lot of state child welfare people call me. You know, I've got this child. They're going to Haiti because the relatives are in Haiti. What do I do? I mean, so they may never get another case, right? It depends on your state, but the hard part, I think, is that we have to do training of people to know that when it happens, where do they go? So to the extent that you can get this information out into your agency, to the other adoption service managers, that would be really helpful. Because we are also trying to inform the judges who have a role in these cases, and they're in the same predicament. But they don't know, you know, we don't know which ones will get the outgoing cases and how many and when they'll get them. But there was a final rule we did on them, which is one of your handouts. We also did a special guide just for state authorities, which we gave as a handout. We also have a web guide on our website for parties, for parents, birth parents, adoptive parents, receiving countries, anybody involved in the adoption. What's the bottom line? Well, if there's an outgoing case, if the child is going to move from the United States to another convention country for the purpose of adoption,
That's going to be covered by the treaty, the IA, and that Rule 22 CFR 97. And here's an example. The Canadian parents adopt a child in Minnesota, and the child's going to emigrate to Canada. It also, just so we're clear too, if you're in a state that's only granting custody for the purpose of immigration and adoption, this still would be covered. It doesn't have to necessarily be a final adoption in the state court. The one very new requirement is that we, as a central authority, are now required to certify those adoptions. So this looks a little bit like an interstate compact procedure, right? It has shadows that kind of procedure almost, but we do not intend to be able to roadblock. Okay, because I do understand those issues. But the bottom line is, Congress, in its wisdom, said that the power to complete the adoption remains with the state court, and they are going to make the certifications in terms of the factual findings to support a determination that the Hague Convention has been complied with. But before the child can leave, they're going to have a Hague outgoing case certificate from us, or a Hague custody declaration where custody for purposes of adoption abroad was granted. So we have on our website the application. All right, so when www.trial.state.gov is where the family will have to go once they complete the adoption to get an application for the Hague custody declaration or the Hague adoption certificate from us. The second big thing in terms of the change to outgoing cases is that the state courts, when they do, in addition to making sure the adoption complies with state law, now has to make these verifications that the adoption complies with the convention. And so we issued the rule that describes those requirements. And again, we've handed that out. I think the main thing to say is that when the rule was in, I don't know if you all do any rulemaking, but this rule was subject to the public comment period. And we did get a number of comments from state welfare authorities concerned about delays. The main issue is please don't delay. But also, please tell us how to do these cases, because we don't have many of them, but we want to have some protection for these U.S. children that are leaving, right? Because until this treaty came into force, there really wasn't, other than state law, there really was no federal protection for a child who's being adopted across U.S. borders. And this treaty does provide a lot of protections for the movement of children before the adoption is approved by both the country of origin, which would be the United States, and the receiving country. It would cover, in addition to private adoptions, which most of us think of might come up in this context, it covers the children in foster care. So your Adopt Us Kids website, when those kids are being adopted by parents overseas, this would apply as long as there's a convention country involved. It does not cover pre-April 1st cases, though. We have a lot of information about transition cases, but the gist of it is if there was an application to adopt, initiation of the procedure before April 1st, then April 1st, 2008, then the new procedures for Hague cases would not apply. So what happens? Well, if you have one of these cases, there's a list of verifications, and I did not spell them all out here because it may be a little too daunting, but they are in the web guide. And basically they have to do with making sure the child's eligible, the proper consents have been found, that reasonable efforts to place the child in the United States have been completed. But all of those are listed in the rule as well as the guide that we handed out. Who's ultimately responsible for making those determinations? It's the state court judge. So they're the ones so they need to put those findings in their order, but they're going to be asking the practitioners, and this may involve your child protection attorneys, to make sure that they are given those findings, the factual verification for the findings and then the findings, so that they can make them in the state court order. That's going to be important because they're going to need to submit that state court order to us to get the Hague adoption certificate. or the Hague Custody Declaration. Well, with that, and you may be helping the family get this, or the family may be doing it itself, or the attorney may be helping them. I can't, I think it could be any one of those advocates for the child. We are not, so you submit the court order with the application, and we're not charging a fee at this point. So when it gets to us, we're going to rely on the state court's findings and make sure that the verifications were made. But if they are, then we're going to issue the Hague certificate or the Hague Custody Declaration for the child. And then once the child has obtained that document, as well as any passport they're going to need, or any visa they may need to enter the other country, they would be eligible to leave the country. They would also have now a certificate that shows their adoption complied with the Hague, which is entitled to recognition in the receiving country, as well as among all the rest of the party countries, which is a good result. The recognition part of it for international adoptions is really key for a lot of reasons, because there's no other law that requires recognition of adoptions across international lines. So this certificate that we give them will have a real life purpose for them as they move on in their new country. And likely they will not be able to enter unless they have the certificate, because the receiving countries know about this, because they're also parties to the Hague. What are some key things in terms of state law? Well, your substantive law on adoption about, what, for example, how to do a consent, what has to be done for the consent to be valid, is still applicable, right? This doesn't preempt that. In fact, it's bootstrapping most of state law, because there is not a lot of substance in the treaty. It just talks about how consents have to be consistent with the law of the country of origin. Since we don't have a federal law of consent, we're looking to the states to continue to apply their law of consent. What are some special things about these outgoing cases that may be new? Well, there has to be a child background study. That's a requirement from the convention. That addresses the child's medical needs, their social environment, their family history. This is going to have to be part of the case file. And if it's not already done, would have to be created for an outgoing case. It can be done by accredited providers, but it also may have to be done by a state public welfare agency. There also has to be a home study, of course, but the home study is going to be on the parents that are not in the United States. And so that home study is going to have to comply with the receiving country's law and also with your state law. Right. The convention prefers that the child's determination about eligibility for adoption and ability to enter the receiving country be made before the adoption. So the receiving country is going to send what's called an Article 5 notice, and the judge and the public entity working on the case would have to get this before the adoption should go forward. And this is the way that the receiving country, say it's Mexico, say, this child is going to meet our immigration requirements and be eligible to enter once you complete the adoption with the Mexican parents in New Mexico. In addition to your state law on consents, there are some substantive provisions in the Convention on Consent, very few, but I put them here, that the consent of the mother is required. If it's required, it may be given only after the birth of the child. That's true in most states, but that it's now true for all outgoing cases. And that it has to be in writing and in the proper legal form. So you can see this mixture, right? We have a federal overlay saying, some bottom line requirements on the consent, but the rest of it's going to be up to state law. And I expect most of the questions I will get when we actually have these cases will be about this interaction between the state requirements and the federal requirements under this treaty. There is a complicated reasonable efforts requirement, but the bottom line on that is some efforts have to be made to find a placement in the United States before the child can be placed for an inter-country adoption. It does cover both the private cases as well as the public domestic authority cases. And I get this question a lot, so I just put it up there, is what happens to the child's citizenship? They keep their U.S. citizenship. They may well gain the citizenship of the country to which they've traveled. And so they're likely to end up as dual citizens. But that's going to depend on the receiving country's law. No, the child does not have to give it up. And we have an extremely extensive, detailed process. If you, American citizen, ever want to revoke your citizenship, people can do that, but most children are not capable of doing that. All right? Yeah.
My question is, if you're placing a child that is in the agency custody with a family who is also U.S. citizens but live in another country, I think I understand that Hague does not apply. Is that correct? Even though the family may be stationed and will be for some time in the other country. Do we?
Yeah, that's a great question. That's a great question. We are getting that question a lot. You know, generally you're right. I would encourage you, we have an email for specific habitual residence questions, which is to send the facts in so that we can opine directly on your case. The reason I suggest that is because ultimately the decision on the jurisdiction is going to belong to your state court judge. So we will give an opinion and input, but we're going to make the caveat that if it gets there and the judge believes that it's an outgoing case and this applies, we're just a federal agency. We're not going to be able to trump that. And we try to explain that when people ask us, right? Because the treaty itself is not very clear, right? You know, it just talks about movement of children and habitual residence, but it's not, it's one of the less precise parts of the federal law is when citizens of the jurisdiction where the child lives are in another country, all right? Mm-hmm. Mm-hmm. Right. Mm-hmm.
I'm sorry, thank you.
Right.
They saw the child on Adopt Us Kids, got interested in the sibling group, and were trying to make the placement, but the family does not live in our state.
Right, I understand. Yeah, that's you know, when we're trying to make those cases still as easy as possible, right? Because we want to match the family and move the case forward. But by the same token, there is movement across national borders, right? So you were trying to balance those interests. Right?
One of your slides says the state law on adoption are not replaced. I've seen both on websites and in New York State, we have an issue in which our state law, according to the interpretation of our attorneys, does not allow us to place out of country. Does Hague trump that law?
Are you in New York?
Yes.
Yeah, I just talked to your lawyer. No, that's a really great question, and I'm glad you brought it up. Based on my conversation with the New York attorney, who was very concerned about that, I think they're going to take the approach that they're going to try to read New York law that it doesn't necessarily prohibit all outgoing case adoptions. That would be a better and more rational way to deal with this new federal law, rather than prohibiting these adoptions and then getting challenged by some private parties, right? So, yeah, I know. I have the name of that person and are just okay. All right, if we want to, you know, so I think we're headed in the right direction. I can't guarantee you what New York will do, but you know, we're hoping to avoid a direct conflict, right? Yeah.
Kind of on that, I guess the same note with that, as far as not being contradictory to state laws,
Right.
policies. Your bullet there regarding reasonable efforts to find a domestic placement for a child must be completed. If our states are promoting placement with relatives and relatives are out of the country, that does not apply then to relative placements?
Part of the rules has a slight exception for relative adoptions. All right. And so, again, you'd have to convince the state, you'd have to take advantage of that exception and argue to the state court that reasonable efforts weren't necessary because it was a relative placement. Yeah.
You said that an attorney would have to be, I guess, certified. How does that happen?
Attorney, the word that we're using for certification is approval. and he or she had to apply to COA or to Colorado, and we have a number of them that did apply, and they had to meet the same standards as the agencies. No difference in standards, just different name. So, frankly, people can tell when they retain whether they're retaining a for-profit or a nonprofit.
Okay.
All right.
Because I deal with a lot of ICPC, which is going to involve these cases.
Right.
So I'm assuming that I have the authority to say, I want to see the certification of this attorney, this private attorney?
You can if he's providing adoption services. If he's just doing legal services, then it's not covered. And we talk about in the rule the difference
Okay.
between pure legal services, and that's why I put those lengthy descriptions of adoption services up there.
All right. Thank you.
And if there's a question, you can call us or write us, and we'll try to just decipher that out, because there is an issue. It is hard to know sometimes where the line between legal services is and adoption services is when certain attorneys provide both.
A question in piggybacking on his question in New York State, if attorneys are not allowed to place out children for adoption in your state, they can be certified by Hague but not to do business in your state if they're not certified by your state to do business.
Right. We actually had that question. So if your state prohibits attorneys from providing adoption services and they get approved by the Department of State, that doesn't change your state law. Right. And there's actually a Q&A in our preamble about that, because that did come up for certain states. They could still do the legal services, and in states that allow them to do adoption services, they can still do it, but they have to be federally accredited. But in a state that prohibits them, they're still prohibited. Anything else on that? Because they were fantastic questions, because this can get somewhat complicated when you actually start thinking about the cases. All right, I'm going to be a little bit faster on the next round of information, because I don't think it affects you as much, the incoming cases. But before I move to that, there is one other rule that I wanted to mention. The Congress has required us to report on all outgoing cases because they want a head count. This came up, obviously, it's a little more than a little bit controversial about U.S. children going overseas, right? Some people think there should have been a bar, like New York, right? Or what New York was thinking about. Some people thought there should have been a 2-3 year wait for the children. They should be on a U.S.-based list for 2 years before they could go overseas. So it is not uncontroversial. But the bottom line is the law came out that the children are covered and they can be adopted overseas, and Congress is interested in how many of them are going. And so there's a reporting requirement that applies to anybody involved in one of these cases, whether it's convention or non-convention. You have to report to us that you were involved, that the case happened. And we have an adoption tracking system, and we have a form on our website to report the information. It's pretty straightforward, to which country they're going, from which state they're coming, and very minimalist information. And the goal of that is that in our annual report, we'll be able to answer the question that everybody has: how many children are leaving the United States for the purpose of adoption?
A question related to that.
Yeah.
New York State is not, because we have a large immigration population. Our issue was with relatives and making
Right.
sure we have an opportunity to do that. But a part of it, I think, also for us is interjurisdictional, the opportunity to be able to have a nationwide ability to check to see first if there are homes available to our children. And we haven't had the ability to do that, although the federal government has talked about interjurisdictional placements and making that more accessible. We still need somehow to be able, particularly for us in New York State, to at least say in terms of diligence efforts that we have checked in our state as well as we've checked throughout the nation before we think of sending a child overseas.
No, it's a very good point, and I regret to report that this treaty and its implementing legislation did not address that. We didn't get any funds to deal with the cross-border placement of children within the United States. Any training, any to enhance the websites. I mean, that's going to be more an HHS and a state issue. I don't think the State Department. Heidi's going to chime in here.
I just want to chime in that there are, on Adopt Us Kids, there are approved and waiting families who are available to take high-needs kids who are waiting to be called, to answer the call. So this has been a very underutilized resource. And so would like you to all look again at that and talk to your staff again about that, because these are families who are looking on Adopt Us Kids, which only features really the harder to place kids, and they're saying they're interested, and they're not getting calls back. So just wanted to mention that. Thank you.
No, it's good. It's good. I just want to be clear that we don't have a mandate statutorily or funding-wise to deal with those opportunities within the United States. So there's the reporting requirement, and now in the outline I'm moving on to incoming cases, because I do know that sometimes states get involved in an incoming case, whether it's in a disruption or a disillusionment, or just because families make inquiries and they figure if you know about domestic adoptions, you know about intercountry adoptions. And so I'm going to quickly go over this. There is a new immigration rules for these cases, and there's the site for them. There's a complicated series of steps, but it involves filing new forms with USCIS, which is the former INS, and these are the names of the forms. The big new step is there's a provisional adjudication of the child's eligibility to enter the United States before the adoption is finalized in the country of origin, which now would be, say, China. And that is important because a lot of parents would adopt overseas and then the child couldn't meet our immigration requirements, and that was a treacherous situation for the child. And so this Article 5 letter, just like we're going to be expecting it from the receiving country in an outgoing case, the Department of State are going to be issuing the same kind of letter in an incoming case. The idea is to get the public authorities to say the child can come before the adoption is finalized. All right. We also, for these incoming Hague cases, in addition to doing the Article 5, which is the State Department's responsibility, will be issuing Hague certificates to these children. So it's a mirror image for the incoming children. If their country of origin complied with the convention and told us that they complied with the convention, and we check and we see that they did, then we're going to give them a Hague certificate or a Hague custody certificate. And then we'll give them the visa and grant the petition. When they're going to come into the U.S. on new visa titles, the orphan definition, they came in on IR3s and IR4s. Now they're going to come in on IH3s or IH4s. The 4 is for the custody for purpose of adoption, and the 3 is for a final adoption. And the U.S. Citizenship Act will still apply to their citizenship. So most of them, if they had a final adoption in the country of origin, once they start to reside here, will be automatic U.S. citizens. Again, they'll be dual citizens usually because they'll retain their country of origin citizenship. The most important thing I can mention from a state point of view is that now, once they get these adoption certificates from us, they have to be recognized in the U.S. states for all purposes, including reissued birth certificates. And so this procedure where a lot of international families had to readopt under state law, that it should no longer be necessary for a Hague child. That adoption certificate from the State Department is entitled to full faith and credit under the Intercountry Adoption Act. And this hopefully be a cost savings as well as an administrative savings for those children. The other new thing is that if the child came in on custody for a purpose of adoption before the state court can finalize that adoption, they have to see the certificate from us, all right? Because there's a Hague case, we want to make sure it comply with the Hague before the state court finalizes. And so the Hague custody certificate has to be in the court records before it finalizes the adoption. I know I've had a lot of state court judges like, well, I didn't know about that. So we're just trying to get the word out because they're not used to looking for something like this before they finalize. And these are all the important resources and phone numbers for USCIS. They centralized their Hague cases, their incoming cases, in the National Benefits Center in Missouri, and these are their various Hague numbers. If you feel free to give them out to your families. These are all our numbers. Legal questions, visa questions. Mickey that runs Adoption USCA mailbox, and they get thousands of questions. And I think that's my contact information. If you have an issue, yes.
So pretty much now it's well known that they will not have to do the readoption, because that still seems to be an issue that we hear a lot about agencies telling their families they need to readopt in the United States.
Well, if it's a non-Hague case, they should do that. All right, because they don't have the law of the full faith and credit about the Hague certificate. But if it's a Hague case, they can use that Hague certificate for all purposes. It's entitled to recognition by every state and local government. And I think it's just a matter of time before the agencies start to understand that, right? Because readoption's been around for a long time, right? And this is relatively new. All right, I'm going to turn it over to Mickey.
I want to thank you again for having us. I too have been in the adoption area for a long time, and I do regard it as kind of my mission, not, to convert, but I love it so much. I began many years ago overseas with my family in Ecuador, and I started helping children from Ecuador become adopted, and worked with a group of American women who were looking, and at that time, it was in the 70s, there weren't a whole lot of adoptions being done. And so it was a matter of researching and finding agencies that were interested in having one of their families do some groundbreaking work and come to Ecuador and bring back a child adopted. And as a matter of fact, we adopted a child who is now in her 30s, and I want to assure everybody, I always try to assure people that, the bumps and everything, you manage to live through them. I do support Anna Mary's call for, more adoption specialists, because when we were going through the ups and downs, there wasn't much out there, and we had to look high and low for our resources. And it was very difficult. And as you all know, stress in the family can become very, very stressful for everybody. So I do support, and I also think that adoption is such a great area for social workers and for lawyers. And so I love it because it combines the wonderful aspect of making a family with all the various special attributes of social work and law. So I thank you all, and I do hope that somehow we can all recruit more social workers who love adoption as much as we all do here. Let me see if I can work this thing. So I'd like to explain a little bit about what accreditation is for the agencies that have applied to do intercountry adoptions with Hague member countries. As Anna Mary explained, we are the central authority, and we have the Colorado Department of Human Services and the Council on Accreditation as the two accrediting entities. Colorado is accrediting and reviewing those agencies in the state, and the Council on Accreditation has the rest of the United States, and also I think accredited one agency in Colorado because they were also accredited by COA. As the central authority, there are many responsibilities that we have. And one is that we supervise and monitor how these requirements are being implemented by the accrediting entities. And the other really big job that we're going to have develop is compiling data and information about other convention members as the central authority. We have to compile information about how their requirements are so that we can explain them and know them, and also explain to them what our requirements are. And right now we're talking with a number of countries, and they all are very much puzzled by our structure because it's very different from theirs. So we're doing a lot of discussions with France, Belgium, the Netherlands, and I think we also have been speaking with the United Kingdom and Brazil. And when we have new information about our agencies that have been accredited, we have to inform the Hague Permanent Bureau and the other central authorities of the accreditation status. And if there are agencies that eventually, or we hope there aren't too many, that lose their accreditation or are denied, we also have to inform them. And I want to emphasize that this is an important resource for states to know which agencies are approved and accredited for them. And I also need to tell you that on November 17th, we are going to have our own website, so you won't have to go to the travel.state.gov, and it will be www.adoption.state.gov, and all of the information on adoption, intercountry adoption, will be on that site, and hopefully much more accessible for you all. As Anna Mary mentioned, we're going to be tracking the number of outgoing and incoming adoption cases on our adoption tracking service, which will allow us to not only count but also in other ways know what happens to some of these cases in terms of disruptions and dissolutions. And we have to retain convention records pertaining to convention adoptions for 75 years. And as Anna Mary mentioned, we have to submit this annual congressional report, which is in our enabling legislation. A number of items we have to report on, and one is fees. Each of the accredited and approved adoption services providers will have to enter into the adoption tracking service the fees that they charge for various services that they provide. Also, the length of time that adoption takes will also be a part of their input. So hopefully someday, probably not this first report, but maybe next year's, we'll be able to have a more comprehensive view of what intercountry adoption looks like in the United States. The Hague Complaint Register is also part of this tracking service, and we want to invite as many of you who would like to. It is open to the public to submit complaints about accredited adoption service providers concerning Hague standards and regulations. We really want to know if there are agencies that are not doing what they should do, and some of the issues are, of course, fee reimbursements, complaints, how they handle complaints from their families, and what information they provide to their families about the whole process of their agency. And again, we will be issuing adoption certificates and declarations in outgoing cases, and we designate, monitor, and supervise accrediting entities. This is going to be an ongoing process, as you can imagine, because now that most of the accreditation has of the applicants has been completed, we now will be monitoring and making sure that they stay in substantial compliance with the standards that they met when they were being evaluated. And I just wanted to show you a little bit about how, what the process looked like for an agency that applied for accreditation. They had to submit these various forms, the executive verification, their state licensing and regulatory information, their governing body profiles, collaborative relationships. Collaborative relationships meant agencies with whom they've had working relationships, and under the Hague, they have to have signed agreements. And this also includes foreign supervised providers, programs with whom they work overseas. Employees had to meet certain requirements in the way of qualifications. And as you can see, we looked at budget and the audit, insurance issues, risk assessment requirements, compensation of the executive director. And the other day I was in Colorado, and the phrase is unreasonably high, and they all laughed and they said, "What do you mean unreasonably high? Wouldn't it be unreasonably low?" For many of these executive directors, as you know, it wouldn't be the issue wouldn't be excessive. It would be managing, because most adoption agencies have minimal budgets. And this is what the form looked like, the governing body profile, and the collaborative relationships. One of the things that we looked at was the credentials and previous experience of the staff. And the site visit was to each of the agencies that applied for full accreditation or approval. And so they reviewed on-site documents, case records, personnel records, and then they interviewed staff, board members, adoptive parents, supervised providers, and other stakeholders. And I went on one, and it took a couple of days, usually about 2 or 3 with 2 people, and so it was quite thorough. And one of the requirements was that there will be a system with which to review and evaluate the agency, and so that was called the substantial compliance. It is not like a regulatory one in that yes or no. It's a substantial compliance, and it's a 4-point rating system, which is a number 1 and 2, 3, and 4. That the evaluators use to determine the degree of compliance. Now, there were mandatory standards and critical standards and foundational standards. And the standards were divided and categorized depending on how much they represented the principles of the convention, and in terms of also the ethical issues that are addressed. Critical, I can give you, a little less in terms of ethics, but maybe in terms of practice, I think. And foundational, how the agency functioned. And so in order to be accredited, approved, or they had to receive 100% on all of the mandatory and 100% of all applicable critical standards, and no rating of non-compliance on any foundational standard. And I want to emphasize that this was a system that was used, and some of the agencies that have been either denied or, that were denied have been complaining that they were not evaluated or rated on a scale or in a system that they could understand. However, as you can see, that this was pretty well developed, and that this is something that was accessible to them when they and before they applied. So, and this is something that is also available to anyone else who wants to know about the substantial compliance system that was used to evaluate the agencies. The post-commission review report was a compilation of the deficiencies and how the agency replied and submitted reports or answers in terms of the deficiencies, and then the final evaluation, whether they were accredited or not. So we had slightly over 300 adoption services applying. This first list was available on February 29th. And this number goes up as agencies become accredited or approved. We have 21 agencies still being in process of being evaluated. And so this number will change over time. We've had 17 adoption services denied. And there was one agency that was denied, but it resubmitted its application. Actually, it submitted a new application, and it was accredited. So we were very happy to have them join the accredited list. So our accrediting entities, Colorado and COA, have to do the accreditation. They have to monitor compliance, and they have to investigate and respond complaints about accredited agencies, and take adverse action, which Anna Mary listed. And they also will be renewing applications for accreditation and approval. These will be staggered the first time so that COA doesn't have to go through the whole process in 1 year again. Some of the agencies that did very well will be renewing in 4 years, and those that had more deficiencies will be renewed in 2 or 3 years. And they will also be collecting data, and they will be maintaining records and report to us and to state courts. And they will be helping take appropriate action if an agency has to close its doors or it goes bankrupt. There are requirements in each of the 4 agencies to show what their plan is if they are going to close. And again, this is about the Hague Complaint Register, and it's on our travel.state.gov, and it will be on our adoption website. And this is just a little bit about our supervised providers, which we talked about. These are agencies or organizations with whom accredited agencies will be working. They don't have to be accredited if they are only going to do for a certain adoption service. For example, there could be a social worker who is only going to do a home study for a family, and that family will be working with another agency, accredited agency. So an exempt provider, and this is something that many social workers should know, they can be an exempt provider only if they do a home study for that family. And they must have it approved by an accredited or temporarily accredited or approved provider. And we want everybody to know that these primary providers are held responsible for actions of their foreign supervised and exempt providers. I want to let you know, too, that I'm really excited about having foreign families considering children that are available on some of these state listings. And I wanted to bring you up to date in that our Consul General in Paris, Catherine Berry, has worked from the beginning almost on The Hague, and she has been talking with many of the French officials about the Hague process. And there is an agency in Georgia that is also working with the French officials to develop a relationship so that children who are listed on state listings can become considered and hopefully adopted by families in France. And we're hoping that there'll be other countries too. And I think I'm just really hopeful that this opens opportunities for children who might not have any other opportunities. And so I'm hoping that you'll take that information and get in touch with me and Anna Mary so that we can work with all of you to help this happen. So thank you. And if there are any questions,
Just a quick question. This came up the other day, and I guess I'm curious about it also. We have to report dissolutions for our 4B plan. Can you give us any guidance on that process, or do either one of you deal with that?
Thanks for that very practical question. The IAA put in a requirement that the states have to report on the inter-country adoption disillusionments because, again, they wanted to counter any anecdotal information. And so the reporting is through your regular HHS reports, and we've already gotten some from the states that have indicated, whether it's 1 or 2 or 3, and that's basically where you report. And then HHS is going to give us the information to incorporate in our congressional reports.
According to one of the slides that you showed earlier, there should be a Hague custody certificate from the sending Hague country, for example, India, where they grant custody to the couple, and the couple comes back to the United States, and they usually finalize in their home state.
It should be one starting as of April 1st from the United States.
Okay.
The countries of origin are going to vary about whether for a non-final proceeding, like a custody proceeding, whether they give some kind of document.
Okay, so they're not required to do a Hague custody certificate?
If it's a custody case, countries of origin are going to vary about how they document it, because the Hague...
It could be just simply their court order then?
Right,
Okay.
right, exactly. But that's a good question. That's a good question because we are being more formal about it, and just in case the country of origin doesn't do it, we're going to give the custody certificate.
I just have a question concerning subsidy, eligibility for adoption assistance. So we have children who are being, from the states who are being adopted by parents out of country.
Right.
What is the Department of State saying concerning subsidy following these children?
Okay, that is really my HHS colleagues, but we've discussed that issue, all right, because they're the ones with the money and the rules, right? But my understanding, and Heidi can correct me if I'm wrong, is that the subsidy follows the child. Okay.
In most cases, they will not be eligible. So, Jane.
You're talking about a child in the custody of a state agency that's being adopted by in placed in another country. They'd have the same eligibility that any child.
I'm sorry, I thought you meant income.
Yeah, I figured you were thinking the other direction, but they would have the same eligibility. The challenges are kind of the same challenges we have with getting medical coverage in different states, and that's something we'd have to, would be dealt with on a case by case. But the subsidy itself should follow the child.
The outgoing, definitely. I'm sorry, I thought you meant the incoming. And I just wanted to see if we could get Deborah Goodman to talk just for a couple minutes, because her state has done this. They have not only placed with relatives, but I believe some non-relative cases in other countries. And so I had asked her if she could just speak for a couple minutes about that.
Most of the children that we have placed were actually DHS custody children, but they were placed with military families on military facilities. And so they actually were placed with American families. To date, we have placed 37 children abroad, and we have done that in, let's see, Japan, Korea, Spain, the Netherlands, Germany, and England, I believe, and Korea. But it's wherever we've had a military facility. So the family actually has declared a state as their state residence. So then we're actually making the placement of an American child with American family. It has presented some challenges in that, in addition to all of our own state rules and regulations, you have to satisfy the military. And so there's actually a higher level of scrutiny because we contract out and we do a purchase of service agreement for the supervision and the services that we would expect of in supervising any family that adopts from our Oklahoma agency. So we would expect that level of supervision. But in addition to that, the military has a set of standards. So our first hurdle was to prove to the folks at our agency that these children were not going to be just sent abroad and left hanging. And once we were able to show them that we were going to be purchasing services from someone who is actually Hague certified, and also knew those regulations, knew the difference between the two, but also would provide the same level of services. We get reports from them. We now are in the process where they first initially had one of our staff persons to come over once a year where we were able to meet some of those families. Now our state is actually providing for us to go over once a year to engage with the family. Now we bring the families over before we ever send children abroad. We will bring them over, and they stay for an extended period of time. So it's not like we're just sending our children out without knowing or without meeting the family. And when I say they come over for a week, and sometimes it's longer than that, where they actually stay in the hotel. They meet the children. They meet, if there's extended family, they get to meet those folks. They get to engage with the caregivers. And so we have an expectation that it's not just they're coming over for vacation, but they're coming over to really feel what it's like to live with the children. We've had 2 disruptions. We made 39 placements, but we had 2 disruptions. We think that's a pretty good rate so far. And some of these most of them were children that we had on Adopt Us Kids. And our state does not list every child on Adopt Us Kids. We try to exhaust all avenues that we have within our state, and we want to make sure that we can answer any calls that come in for Adopt Us Kids. So we're pretty selective about those kids. So if there's an identified resource, they're not on there. It's only the children that are sibling groups. It will be older kids on there, and you will see minority kids, and you will see kids that we have tried all kinds of efforts. The first 2 girls that were placed had actually attended all kind of adoption parties. They had been on waiting child. We had done everything possible, but it was a family who was stationed in Germany who saw the children on the internet, fell in love with them on the internet, came over, had a couple of visits, and we pay for them to come over and supervise that visit during that process. And they, because they have had such a successful placement, they have gone on and actually been our spokesperson over in Germany. They have a support group over there. We contract out with or do a purchase of service agreement with Adopt Abroad, and they have provided every kind of service that, including counseling service for the family. It's the same issues that families will experience here in the state, so you have to protect that those services are there. But they have done wonderful. We get home assessments all the time from everywhere now as a result, because the word is starting to get out that we will accept their home assessments. Many assessments do not cover everything that we would look for in assessment, and we're not bashful about saying, can you answer these questions for us? Either they can or they cannot. If they cannot, that's not someone we're going to be looking seriously at. I don't want to imply that we're looking at placing our children. Our belief is, and I think this morning from Virginia we had a discussion, because I do believe it's all of our children, and I kind of look at it as just like I would look at one of your states, at one of your families. I have an expectation that in good faith you're really getting in there assessing that family, and that you would not certify that family, but at the same time, if I see some loopholes that we need to question further, we feel like we don't need to be bashful about that. And so we do that, but at the same time, I think if we have explored, we've done all the diligent search that we cannot identify family members. The question came to me, well, do you consider this a loss? I do consider our children have many losses, and it includes family members, it includes community, and so we do try to avoid those things if we can, but the bottom line is our children need families. So if we can provide for them a family, maybe that family can help them compensate for some of the losses that they have experienced while in the child welfare system. And it's our job to try to minimize those losses if we possibly can. But it's been a great resource for us. And it has helped children who would have otherwise been in our system even more years than they were in before we found the home. So we're happy about it, and it works for us.
Thank you, Deborah. And absolutely.
I know military families, many of us have worked with military families over the years, but it's really exciting to hear what Oklahoma's done. And I just want to give you an aside. My husband and I were on holiday in Germany last year, and we were staying at a place that had the Armed Forces' network on, and they showed one of the PSAs from the Adopt Us Kids campaign. I can tell you, I just hooped and hollered. I could not believe I was in Germany, seeing, a connection to the campaign and our kids. But that's such a great resource, and to make our kids available to those families is great.
So thank you. And I just think if we had more time, I just think this is like a coming attraction. Like, we're going to try to figure this out. We're going to try to get some training and technical assistance. We're going to continue our relationship here with the State Department. And we didn't even have time also to get into a whole nother topic, which is sometimes kids that come to us from other countries disrupt here and need services. And what do we do about that? And so hopefully maybe sometime we can invite these lovely ladies back and have further discussions. But I'd just like to thank them for coming, and thank you for the time.